Article 14. Aggravating circumstances. The following are aggravating circumstances. 1. That advantage be taken by offender of his public position. Requisite. 1. The offender is a public officer. 2. The commission of the crime would not have been possible without the powers, resource, and influence of the office of he hold. Essential. Public officer use the influence, prestige, or accidency which his office give him as the means by which he realize his purpose. Failure in official is tantamount to abusing of office. Wearing the uniform is immaterial. What matters is the proof that he indeed took advantage of his position. 2. That a crime be committed in contempt of or with insult to the public authorities. Requisite. The offender knows that a public authority is present. 2. The public authority is engaged in the exercise of his function. 3. The public authority is not a victim of the crime. 4. The public authority presence did not prevent the criminal act. Example, Juan and Pedro are quarreling and the municipal mayor, upon passing by, attempt to stop them. Notwithstanding the intervention and the presence of the mayor, Juan and Pedro continue to quarrel until Juan succeed in killing Pedro. Person and authority. Public authority who is directly vested with jurisdiction has the power to govern and execute the laws. Example of person in authority. 1. Governor. 2. Mayor. 3. Barangay captain. 4. Councilors. 5. Government agents. 6. Chief of police. Rule not applicable when committed in the presence of a mere agent, subordinate public officer charged with the maintenance of public order and protection and security of life and property. Example, Vayu Vice Lieutenant, Vayu Councilman. 3. That the act be committed with insult or in disregard of the respect due to the offended party on account of his rank, age, sex, or that it committed in the dwelling of the offender party if the latter has not given provocation. Circumstance, rank, age, sex may be taken into account only in a crime against person or honor. It cannot be invoked in crimes against property. Rank refers to high social position of or standing by which to determine one's pay and emolument in any scale of comparison within a position. Age. The circumstance of lack of respect due to age applies in case where the victim is of tender age as well as of old age. Sex refers to the female sex, not the male sex, not applicable when 1. The offender act with passion and obfuscation. 2. There exists a relation between the offender and the victim, but in cases of divorce, decrease where there is a direct bearing on their child, it is applicable. 3. The condition of being a woman is indispensable in the commission of the crime. Example, parricide, rape, abduction. Requisite of discharge to rank, age, or sex. 1. Crimes must be against the victim person of his honor. 2. There is deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. Discharge to rank, age, or sex is observed by treachery or abuse of strength. Dwelling must be building or structure exclusively used for rest and comfort. Combination house in store not included. 1. may be the temporary as in the case of guests in the house or with spacers. So the basis for his is the sanctity of privacy. The law occurred to human abuse. Dwelling includes dependencies, the foot of the staircase and the enclosure under the house. Elements of the aggravating circumstances of dwelling. 1. Crime occurred in the dwelling of the victim. 2. The provocation on the part of the victim. Requisite for provocation, all must concur. 1. Given by the owner of dwelling. 2. Sufficient. 3. Immediate to the commission of the crime. When dwelling may and may not be considered. When it may be considered. Although the offender fired the shot from outside the house as long as his victim was inside. Even if the killing took place outside the dwelling so long as the commission began inside the dwelling. When adultery is committed in the dwelling of the husband, even if it is also the dwelling of the wife, it is still aggravating because she and her paramour committed a grave offense to the head of the house. In robbery with violence against person, robbery with homicide, abduction, or illegal detention. If the offended party has given provocation, if both the offender and the offended party are occupants of the same dwelling, in robbery with force upon things it is inherent. When it may not be considered, the victim is outside his/her dwelling. If offended party are not occupants of the said dwelling. 4. That the act be committed with abuse of confidence or abuse ungratefulness. Requisite of abuse of confidence. A. Offended party has trusted the offender. B. Offended abuse such trust. C. Abuse of confidence facilitated the commission of the crime. Requisite of obvious ungratefulness. A. Ungratefulness must be obvious that is there must be something which the offender should own the victim a debt of gratitude for. Note, robbery or theft committed by a visitor in the house of the offended party is aggravated by obvious ungratefulness. Example, a jealous lover, already determined to kill his sweetheart, invited her for a ride and during that ride, he stabbed her. Abuse of confidence is inherent in 1. Malversation, 2. Qualified theft, 3. Estafa by conversion, 4. Misappropriation, 5. Qualified seduction. Number 5. That a crime be committed in the palace of the chief executive or in his presence or when public authorities are engaged in the discharge of their duties or in a place dedicated to religious worship. Requirements of the aggravating circumstances of public office. A polling precinct is a public officer during election day. Nature of the public office should be taken into account like a police station which is on duty 24 hours a day. Place of the commission of the felony. If it is Malacanang Palace or a church is aggravating, regardless of whether state or official function are being held. As regards other place where public authorities are engaged in the discharge of their duties, there must be some performance of a public function. The offender rather must have intention to commit a crime when he entered the place. Requisite for aggravating circumstances for place of worship. 1. The crime occurred in the public office. 2. Public authorities are actually performing their public duties. 1. The crime occurred in a place dedicated to the worship of God regardless of religion. 2. Offended must have decided to commit the crime when he entered the place of worship. When paragraph 2 and 5 of Article 4 are applicable, committed in the presence of a chief executive in the presidential palace or a place of worship, committed in contempt of a public authority. Public authorities are performing of their duties when the crime is committed. Same. When the crime is committed in the public office, the officer must be performing his duties except in the presidential palace. Outside the office, still performing duty. Public authority may be the offended party. Public authority is not the offended party. 6A. That the crime be committed in the night time or in an uninhabited place by a band, whenever such circumstances may facilitate the commission of the offense. Nighttime, uninhabited place or by a bang aggravating when. Impunity means to prevent the accused being recognized or to secure himself against detection of or punishment. Nighttime begins at the ends of dusk and ending at dawn, from sunset to sunrise. Uninhabited place, one where there are no house at all, a place at a considerable distance from town, where the houses are scattered at a great distance from each other. 1. It facilitates the commission of the crime. 2. Especially sought for by the offender to ensure the commission of the crime or for the purpose of impunity. 3. When the offended took the advantage thereof for the purpose of impunity. 4. Commission of the crime must have begun and accomplished at night time. 1. Commission of the crime must begin and accomplish in the night time. 2. When the place of the crime is illuminated by light, nighttime is not aggravating. 3. Observed by treachery. Requisite. The place facilitated the commission or omission of the crime. 2. Deliberately sought and not incidental to the commission or omission of the crime, taken advantage of for the purpose of impunity that should be considered. There is whether in the place of commission of the offense there was a reasonable possibility of the victim receiving some help. 6b. Whenever more than 3 armed malefactors shall have act together in the commission on an offense, it shall be deemed to have been committed by a band. Requisite. If one of their 4 armed malefactors is a principal by inducement, they not form a band because it is undoubtedly connoted that he had no direct participation. Band is inherent in robbery committed in the band brigandage. It is not considered in the crime of rape. It was been applied in treason in the robbery with homicide. 1. Facilitate the commission of the crime, deliberately sought, taken advantage of for the purposes of impunity, for there must be 4 or more armed men. 7. That a crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity of misfortune. Requisite. Committed when there is a calamity or misfortune. 1. Conflagration. 2. Shipwreck. 3. Epidemic. 2. Offender took advantage of the state of confusion or chaotic condition from such misfortune. Basis. Commission of the crime adds to the suffering by taking advantage of the misfortune. Based on time, offender must take advantage of the calamity for or misfortune. Distinction between paragraph 7 and 12 of Article 4. committed during a calamity of or misfortune, committed with the use of wasteful means. Crime is committed during any of the calamities. Crime is committed by using fire, inundation, explosion, or other wasteful means. 8. That a crime be committed with the aid of armed men or person who ensure of afford impunity. Based on the means and ways. Requisite. 1. The armed man or person took part in the commission of the crime, directly or indirectly. 2. That the accused availed himself of their aid or relied upon them when the crime was committed. Exemption. When both the attacking party and the party attacked were equally armed, though not present when the accused as well as those who cooperate with him in the commission of the crime act under the same plan and for the same purposes. 3. Casual presence or when the offender did not avail himself of any of their aid or did not knowingly count upon their assistance in the commission of the crime. With the aid of armed men. Presence even if one of the offenders merely relied on their aid. Actual aid is not necessary. By a band. Requires more than 3 armed malefactors who all act together in the commission of an offense. If there are more than 3 armed men, aid of armed men observed in the employment of a band. 9. That the accused is a recidivist, one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime embraced in the same title of RPC. Basis. Greater perversity of the offender as shown by his inclination to commit crimes. Requisite. 1. Offender is not trial for offense. 2. He was previously convicted by final judgment of another crime, that both the first and the second offense are embraced in the same title of RPC. The offender is convicted of the new offense. Recidivism must be taken into account no matter how many years have invented between the first and second felonies. Pardon does not obliterate the fact that the accused was recidivist, but extinguishes the penalty in his effects. To prove recidivism, it must be alleged in the information and with attached certified copies of the sentence rendered against the accused. Exemption. If the accused does not object and when he admit of his commission and on the witness stand. 10. The offender has been previously punished for an offense to which the law attached an equal or greater penalty or for 2 or more crimes to which it attached a lighter penalty. Reiteration or habituality. It is essential that the offender be previously punished, that is, he has served sentence. Part 10 speak of penalty attached to those offense, not the penalty actually imposed. Reiteration. Necessary that offender shall have served out his sentence for the first sentence. Recidivism. Enough that final judgment has been rendered in the first offense. Iteration. Previous and subsequent offense must not be embraced in the same title of the code. Recidivism. Same title. Reiteration. Not always an aggravating circumstances. Recidivism. Always aggravating. Habitual delinquency. When a person within a period of 10 years from the date of his release at or last conviction of the crimes of serious or less serious physical injury, robbery, theft, estafa, or falsification is found guilty of any of said crimes a third times or oftener rather. Quasi-recidivism. Any person who shall commit a felony after having been convicted by final judgment before beginning to serve such sentence or while serving the same shall be punished by the maximum period of the penalty prescribed by law for the new felony. Four forms of repetition. Recidivism. 1. Generic. 2. Reiteration or habituality. Generic. 3. Multiple recidivism or habitual delinquency. Extraordinary aggravating. 4. Quasi-recidivism, special aggravating. 11. That the crime be committed in considered of a price, reward, or promise. Requisite. At least two principles. 1. The principal by inducement. 2. The principal by direct participation. 3. The price, reward, or promise should be previous to and in consideration of the commission of the criminal act. Applicable to both principles. 12. That the crime is be committed by means of inundation, fire, poison, explosion, standing a vessel, or intentional damage thereto, or derailment of a locomotive, or by use of any other artifice involving great waste or ruin. Requisite. The wasteful means were used by the offender to accomplish a criminal purpose. 13. That the act be committed with evident premeditation. Essence of premeditation. Requisite. The time when the offender determined to commit the crime. 2. An act manifestly indicating that the culprit has clung to his determination. 3. A sufficient lapse of time between the determination and execution to allow him to reflect upon the consequence of his act and to allow his conscience to overcome the resolution of his will. Conspiracy generally presupposes premeditation. When the victim is different from that intended, premeditation is not aggravating, although it is not necessary that there is a plan to kill a particular person for premeditation to exist. Plan to kill first to person one meets general attack on a village for as long as it was planned. The premeditation must be based upon external fact and must be evident, not merely suspected, indicating deliberately planning. Evident premeditation is inherent in robbery, adultery, theft, estafa, falsification, and etc. That craft, fraud, or disguise be employed. Craft involved intellectual treachery and cunning on the part of accused. It is employed as a scheme in the execution of the crime. Accused pretended to be members of constabulary accused in order to perpetrate rape, use chocolates containing drugs. Fraud involves insidious words or machination used to induce victim to act in a manner which would enable the offender to carry out his design. As distinguished from craft, which involves act done in order not to arouse the suspicion of the victim, fraud involves a direct inducement throughout entrapping or beguiling language or machinations. Disguise resorting to any device to conceal identity. Purpose of concealing identity is a must. Distinction between craft, fraud, and disguise. Craft involved the use of intellectual trickery, and cunning to arouse suspicion of a victim. Fraud involved the use of direct inducement by insidious words of machination. Disguise involved the use of device to conceal identity. Requisite: the offender must have actually taken advantage of craft, fraud, or disguise to facilitate the commission of the crime. Inherent in estafa and falsification. 15. That advantage be taken of superior strength or means be employed to weaken the defense. To purposely use excessive force out of the proportion to the means of defense available to the person attacked. Requisite of means to weaken defense. One means are purposely sought to weaken the defense of the victim to resist the assault. Two, the means used must not totally eliminate possible defense of the victim, otherwise it will fall under treachery. To weaken the defense, illustrated in the case where one struggling with another suddenly throws a clock over the head in his opponent while in the said situation. He wants or kill him. Other means of weakening the defense will be intoxication or disabling through the sense, casting dirt of sand upon another eyes. Superiority may arise from aggressor's sex, weapons, or another as compared to that of the victim. Accused attack on an armed girl with a knife, men stab to death the female victim. 2. No advantage of superior strength when one who attacked is overcome with passion and obfuscation of her quarrel arose unexpectedly and the fatal blow was struck while victim and accused were struggling. Versus by a band, circumstances of abuse of superior strength that is taken into account in not the number of aggressors nor the fact that they are armed but their relatives' physical might vis-a-vis the offended party. 16. The act be committed with treachery. Alvosia. Treachery. When the offended commits any of the crime against the person employing means, methods, or forms in the execution thereof tend directly and especially to ensure its execution without risk to himself arising from the defense which the offended party might make. Requisite that the time of the attack, the victim was not in the position to defend himself. 2. That the offended consciously adopt the particular means, method, or forms of attack employed by him. Treachery can't be considered when there is no evidence that the accused prior to the moment of the killing resolved to commit the crime, or there is no proof that the death of the victim was the result of meditation, calculation of reflection. Example, victim asleep, half awake or just awakened, victim grappling or being held stuck from behind. But treachery may exist if attack is face to face as long as the victim was not given any chance to prepare defense. 1. Does not exist if the accused gave the deceased chance to prepare, or there was warning given, or that it was preceded by a heated argument. 2. There is always treachery in the killing of child. 3. Generally characterized by the deliberate and sudden and unexpected attack of the victim from behind without any warning and without giving the victim an opportunity to defend himself. Treachery means, methods, or forms are employed by the offender to make it impossible to hard for the offended party to put any sort of resistance. Abuse of superior strength. Offender does not employ means, methods, of forms of attack. He only takes advantage of his superior strength. Means employed with weakened defense. Means are employed but it only material weakens that resisting power of the offended party. There Where there is conspiracy, treachery is considered against all the offenders. Treachery absorb abuse of strength, aid of armed men by band and means to weaken the defense. 17. That the means be employed or circumstances brought about which add ignominy to the natural effect of the act. Ignominy is a circumstance pertaining to the moral order, which adds disgrace and obloquy to the material injury accused by the crime. Applicable to crime against chastity, rape included, less serious physical injury, light or grave coercion, and murder. Requisite: crime must be against chastity, less serious physical injury, light or grave coercion, and murder. 2. The circumstance made the crime more humiliating and shameful for the victim. Example: accused embraced the case the offended party not out of lust but out of anger in front of many people. Rape in front of the husband, rape successively by the 5 men, tend to make the effect of the crime more humiliating. Ignominy not present where the victim was already dead when such acts were committed against his body or person. 18. That the crime be committed after an unlawful entry. Unlawful entry: when an entrance is affected by a way not intended for the purpose means to effect entrance and not exist. Why aggravating? One who act not respecting the walls erected by men to guard their property and provide of their personal safety, shown greater perversity, a greater audacity, and hence the law punish him with more severity. Example: rapist gains entrance through the window, inherent in trespass to dwelling, robbery with force upon things, and robbery with violence or intimidation against person. 19. That as a means to the commission of the crime, a wall, roof, door, or window be broken. Requisite: a wall, roof, window, or door was broken. 2. They are broken to effect entrance. Applicable only if such act were done by the offender to effect entrance. Breaking is lawful in the following instance. 1. An officer, in order to make arrest by break open a door or window of any building in which the person be arrested is reasonable believed to be. 2. An officer, if refused admittance, may break up open any door or window to execute the search warrant or deliberately himself. 20. That the crime be committed with the aid of person under 15 years of age or by means of motor vehicle, airship, or other similar means. Reason for number 1. To replace so for a possible the frequent practice resorted to by professional criminals to avail themselves of minor taking advantage of their responsibility. Remember that minors are given leniency when they commit a crime. Example: 1. Instructed a 4-year-old climb up the fence and open the gate for him so that he may rob the house. Reason for 2. The counteract the great facilities found by modern criminals in said means to commit crime and flee in abscond once the same is committed. Necessary that the motor vehicle be important to toll to the consummation of the crime. Bicycle not include. Example: Juan and Pedro in committing theft use a truck to haul the applicants from the mansion. 21. That he wrong done in the commission of the crime be deliberately augmented by accusing other wrong not necessary for its commission. Cruelty: When the culprit enjoys and delight in making his victims suffer slowly and gradually, causing him unnecessary physical pain in the consummation of the criminal act. Cruelty cannot be presumed nor merely inferred from the body of deceased has to proven. 1. Mere plurality of words do not show cruelty. 2. The cruelty when the other wrong was done after the victim was dead. Requisite that the injury accused deliberately increased by causing other wrong. That the other wrong be unnecessary for the execution of the purpose of the offender. Ignominy, moral suffering, subject to humiliation, cruelty, physical suffering,